Instant petition has been filed challenging the orders dated 14/06/2019 passed by the Settlement Officer Consolidation, Sultanpur, in appeal in the order dated 22/02/2022 passed by the Deputy Director of Consolidation, Sultanpur, in revision, copies of which have been filed as Annexes 1 and 2 respectively to the writ petition. A perusal of the order dated 14/06/2019 would indicate that an appeal was filed by the petitioners against the order dated 19/01/1980. The appeal having been filed after a period of 35 years was dismissed by the appellate court on the ground of delay in lectures. Being aggrieved, the petitioners filed a revision under Section 48 of the U.P. Consolidation of Holdings Act, which too was dismissed vide order dated 22/02/2022 on the ground of maintainability. Various grounds have been taken by the petitioners trying to explain the laches in filing the appeal before the authority concerned after a period of 35 years. However, a perusal of both the impugned orders would indicate that both the courts below have found that there is no reasonable explanation for delay in filing the appeal after a period of 35 years. Shri Hemant Kumar Pandey, learned standing counsel, has placed reliance on the judgment of this court in the case of Rajendra Prasad vs. Deputy Director of Consolidation and others 2021-151 RD 194 to contend that this court has categorically held that delay in lectures on the part of the litigant will disentitle him to any relief. The court in the case of Rajendra Prasad Supra has held as under. The courts have consistently observed that delay in lectures on part of the litigant will disentitle him to any relief. In this regard, the Honorable Supreme Court has settled the law with clarity and observed it with consistency. The line of authorities on this point are consistent and long. The discussion will benefit from the authorities in point, the Honorable Supreme Court in R&M Trust vs. Kormangala Residents Vigilance Group and others reported at 2005-3 SCC 91 held thus. There is no doubt that delay is a very important factor while exercising extraordinary jurisdiction under Article 226 of the Constitution. We cannot disturb the third-party interest created on account of delay. Even otherwise also why court should come to rescue of person who is not vigilant of his rights. The Honorable Supreme Court in Maharashtra State Road Transport Corporation vs. Balwant Regular Motor Service reported at Air 1969 SC 329 held thus. Now the doctrine of lectures in courts of equity is not an arbitrary or technical doctrine, where it would be practically unjust to give a remedy, either because the party has, by his conduct, done that which might fairly be regarded as equivalent to a waiver of it, or where by his conduct and neglect he has, though perhaps not waiving that remedy, yet put the other party in a situation in which it would not be reasonable to place him if the remedy were afterwards to be asserted in either of these cases. Lapse of time and delay are most material.